Hi, I'm Andrew Berman with the Mortgage News Network. You're watching Beyond Print. Today we have Tom Black, who's a partner over at Black, Manning Graham. Tom, thank you for taking the time out of your day to meet with us.
Certainly my pleasure.
So listen, I want to get right into this. We understand that there were some recent changes with the Texas cash outlaws. Talk a little about that.
Well, the Texas legislature meets for 140 days every 2 years. Now, I've often suggested they switch that and meet for about 2 days every 140 years. It would make life a lot easier for all of us. But this session, they've passed some very interesting legislation, including a provision that will allow Texans to shoot feral hogs from hot air balloons and stuff like that. But the thing you can't make that stuff up. But what they did this session was they passed some changes to the Constitution affecting bringing cash out on an owner-occupied primary residence. We commonly refer to those as Texas cash out or 50A6 loans in Texas. The provisions of the constitutional changes go on the ballot November 7th of this year. And if enacted, they'll be effective on January 1, 2018. But for lenders out there, it's not too early to be getting prepared for those changes. To give you a feel, the last time a constitutional amendment like this was on the ballot, it passed with 78% of the vote.
Wow. So can you talk to us a little bit about the changes that we're going to be seeing?
Well, there's four really important changes. There's some more changes there, but four very important changes that I think lenders need to know about. Under the current law, a home equity loan may not be secured by property designated for agricultural use unless that property is used primarily for the production of milk. Now, people outside of Texas have always been wondering, what are they doing there? What are they doing there? And that really goes back to the original law. It goes back to politics, which goes to the root word, Greek words, poly meaning many, ticks meaning blood-sucking insects. And the night before all of this got passed, the agricultural lobbyist came in to a guy named Bert Solomons. He was the author of the original bill, and said, take us out of there. And 10 minutes later, the milk people were in there saying, put us back in there. So that's why we came up with the crazy provisions. Lenders have had problems with this provision over the last 10 years. And the good news is now it's going away. You can now, effective under the new rules, make a loan on property secured by an agricultural exemption. The second thing that I wanted to talk about was that under the old rule, neither the owner or their owner's spouse could be required to pay, in addition to interest, fees that exceeded 3% of the original principal amount of the loan. So the 3% rule made it difficult to do smaller loans. If you were doing a loan under $100,000, it was really hard to do. Now, this might sound a little counterintuitive, but they lowered the 3% to 2%. But then they took out certain traditional fees. They took out the appraisal fee where it's performed by a third party. They backed out the survey fee, and they backed out the mortgagee, title, insurance, and the endorsement. So that's a big one, and that should allow lenders to make smaller loans than they would under the existing rule. The third change really goes to the old slogan, once a home equity, always a home equity. And that was the rule under Texas law prior today. That's the rule. But going forward, lenders will be allowed to, once a home equity, allow lenders to refinance as a rate and term refinance if four conditions are met. Now, the four conditions are, you got to wait till the first anniversary on the date the loan was closed, which means the date that the old note and deed of trust was signed. You can't have any additional funds other than funds used for the refinance. The CLTV, the cumulative loan to value, can't exceed 80% on the date that the extension of credit is made. And fourth, the lender has to give a notice to the borrower, and the notice will explain to the borrower that they're going to be doing a rate and term refinance as opposed to a cash out refinance. That under a rate and term refinance, there is recourse. So if the borrower goes in default, you could sue for a deficiency judgment on a rate and term. You can on a cash out. But the benefit to the customer is going to be huge, because now they're going to be able to do the loan as a rate and term loan, which is a lot lower priced for them. And the fourth really deals, or change that's really important, deals with HELOCs. Under the existing law, if you have a HELOC, the maximum advance you can take is 50% of the fair market value of the property. And they've changed that rule to become 80% of the fair market value of the property.
Fantastic.
Effective under the new rules.
Great. Do you see any issues with the implementation of the new rules?
Yeah, I do. I think one thing we've created is we've created the Texas version of the black hole. Trade lawyers know what the black hole is, but there's going to be a 12-day window between January 1, 2018 and January 13, 2018, where you can't close Texas home equity loans. And that's because of an Attorney General's opinion back from 1997. And the Attorney General's opinion says that that the required notice doesn't come into effect until January 1 of 2018 in this case. And therefore, if you give it before that date, it's not effective. So we're going to have to wait till it goes into effect on January 1st, 2018. And then we're going to have to give the notice, and then we're going to have to wait the 12 days. So that's going to cause a bit of a problem.
Yeah.
I think there's also implementation problems dealing with that 2%, because they're excluding a third-party appraisal fee. If there's an appraisal fee for in-house, you can't exclude it. And if there's appraisal management fees, you can't exclude those. The survey exception doesn't help a lot, because these are all refinances, and for the most part in Texas, you don't get a new survey on a refinance as long as there have been no substantial changes to the property. And third, although the premium for the state bank's mortgagee policy of title insurance is excluded, it doesn't exclude your settlement fees, your notary fees, recording fees, and the language doesn't match the nomenclature from the Texas title insurance. So exactly what is excluded, which endorsements, is it just the T42 endorsement or the T42.1 endorsement? That's not necessarily clear. And the third area that I see lawyers will want to wrestle with, and that is there's a provision in the constitutional amendment that says this rule is prospective. So that means that you can make a loan on agricultural property prospectively. It's not retroactive. So that makes a lot of sense. The problem is that the provision dealing with being prospective is a temporary provision that expires at the end of the year. So what does that mean going forward? If you've got loans that need to be cured that were before that period, after that period, are there different rules that apply? We don't know the answer to that, but your attorneys are going to want to take a look at that.
Great. So where do we find out more information, and how do we connect with you?
Well, to get more information, I'd suggest that you go to our website, which is www.bmandg.com, blackmanandgraham.com. Go under articles and under Texas cash out rules. And there's a couple articles we have. We also have a manual, a Texas cash out manual that people kind of use as the Bible of Texas cash out lending. And also feel free to give us a call. We have 13 lawyers. We all answer our own phones. So our number is 972-353-4174.
Fantastic. Tom, thank you so much for taking the time out of your day to meet with us to talk about this.
I appreciate it. Have a good day now.
I'm Andrew Berman with the Mortgage News Network. Thank you for watching.